is Paul Dubois, and I'm the legislative chair of the CDRC. And I want to say at the outset, I do appreciate the efforts of Senator Jackson's staff to amend the bill, though we are not yet satisfied with it. I also appreciate her kind words about arbitrators. The part of the bill that concerns an arbitrator reappearing in cases is not a major problem for us. We think it needs some tweaking, which I put forth in my letter of June 14th, so I won't discuss that today. What I'm concerned about is the section which requires an arbitrator to refund fees if a motion to vacate is granted. Now, whether you support this bill or oppose it, the fact is the bill has many flaws in it and goes beyond the idea of transparency that Senator Jackson seeks. And I have 8 different points I want to discuss. First of all, the bill destroys arbitrator immunity. Every other state and all the federal courts allow for arbitrator immunity. If this bill passes, California will be the only state that does not have arbitrator immunity. Second, even though I think the idea of the bill is, I don't know what happened here. Well, I'll go without it. I think the idea, can you hear? The idea of the bill is concerning lack of disclosure. The bill goes way beyond that. And basically, an arbitrator will be liable to refund the fees in any motion to vacate that is successful, except where the motion to vacate is for exceeding powers or postponing a failure to postpone a hearing. Third, and this is very important, the bill may very well be unconstitutional. Although the arbitrator now has the right to appear and be heard at a hearing on a motion to vacate, the arbitrator is still not a party to that hearing. So if the court decides to assess the arbitrator with the fees, the arbitrator can't appeal. He or she is not a party. So basically, you have, under the bill, you'll have a court assessing liability to a person who is neither a party to the case and has no right of appeal. And that is unfair. The bill also allows all parties to recover fees. So a party who loses, a corporation that loses the motion to vacate still can recover the fees from the arbitrator. If an arbitration has 3 arbitrators and 1 arbitrator fails to disclose, all 3 arbitrators have to refund the money, even though the 2 of them didn't do anything wrong.
So I'm going to need you to wrap up.
What's that?
I'm going to need you to wrap up.
Okay, I got 3 more points very quickly. An arbitrator is liable for failing to disclose what the provider has for meetings. Arbitrators don't know what the provider does. They have no idea. They can't disclose something they don't know about. And finally, the bill absolves an arbitrator for harmless error. But harmless error is not a ground for vacatur, so I don't know what that harmless error section does. So I think the bill needs reworking, and the CDRC therefore opposes it.
Thank you. Next witness, please.
Thank you, Mr. Chairman, members of the committee. Hal Dassinger with the Civil Justice Association of California. We're opposed to the bill because it will limit the ability of arbitration companies and arbitrators to function and making arbitration less useful as an alternative means of resolving disputes more cheaply and more quickly than available in the civil court system. Some companies have dozens or hundreds of neutrals, any one of whom could be performing arbitration services at any given time. Some of them will be providing services as neutrals to companies that are repeat users of arbitration. This bill would act as a ban on those companies marketing to their most frequent users. That's a practical barrier. Some neutrals will be providing services for parties that are frequent users of arbitration, and they will be unable to schedule future work during the pendency of that arbitration, which could be a day or 2 or a week or a month or 6 months. That's a practical barrier that makes it very difficult for the arbitration to function. Current law requires extensive disclosure about the prior history between an arbitrator and the parties, and we think that that covers the disclosure requirements adequately. Current law also requires arbitrators to abide by rules set forth by the Judicial Council regarding their ethical behavior, provides for vacatur of an award if there's an ethical breach. And your prior witness mentioned there was at least one company banned from arbitrating in California because of their marketing practices. We believe the system is working. Ask for your no vote. Thank you.
Thank you.